right, so here, let's go. Let's start. So why don't you turn to page 13 in the front part of your book, and we're going to look at a section called Broker Fast Facts. So Broker Fast Facts on page 13 in the front of your book. Let's review these Broker Fast Facts that you do need to know. Okay, here we go. So independent contractors. Now, this is just a standard facts that you should be aware of. Independent contractors who are paid more than $600 a year should receive a Form 1099, and you'll know this. Like once you become a real estate agent, you should receive, actually by the end of at the end of January each year, you'll receive a 1099 from your broker, as well as from anyone else that you've done work for. Even if you drive Uber or you do Lyft or any of these other, part-time, we're called a gig. We're in a gig economy. They have to send out 1099s, and that's not only 1099s for work that you do, but it's also, bank interest, any kind of statements that you get as far as if you have stock accounts, bank accounts, mortgage interest, anything like interest is 1099. Okay, so be aware of that. Next, we look at compensation. Number 2, the second bullet point. Compensation must be related to output, not hours worked, if considered an independent contractor. Otherwise, you'd be considered an employee for tax purposes. So what we're talking about here is the state and the government, the federal government and the state government, they're very strict on making sure that you're not treated as, they don't want you to be treated as an independent contractor, but work like an employee. In other words, there's benefits to the employer if they treat you like an independent contractor, because they're not paying the other half of your Social Security taxes. In other words, you pay all of the other half of your Social Security taxes when you're an independent contractor. So that's a big financial benefit to the employer. Plus, the employer doesn't have to pay your workman's compensation. You have to, actually, you don't pay it, they don't pay it, you don't get it. So it's a big deal when it comes to you being an independent contractor. You can't collect unemployment in most circumstances when you're an independent contractor. So it's a big deal. This is all like a real big deal. And real estate agents, you'll find out that when you're a real estate agent, you can't collect unemployment when you have an active license. So there's a thing that we have in real estate called putting your license in abeyance. A-B-E-Y-A-N-C-E. Let me spell that for you again. A-B-E-Y-A-N-C-E. Putting your license in abeyance is when you have an active license, but you don't want it to be active. So you contact the Department of State and you say, you know what, I'm not going to be active for a while. I've got some personal things I need to take care of, but I don't want to lose my license and I don't want to give up my license. So you put your license in abeyance. And I'm sharing this with you because you don't usually see this information shared anywhere. It's not in your book and you're not going to be tested on it. But you might have to do it sometime. For example, if you have a real estate license and you're holding another job and you have to collect unemployment, you're going to have to put your license in abeyance to be able to collect unemployment. Otherwise, you'll be flagged in the unemployment system and you won't be able to collect. It'll slow you down from being able to collect unemployment. That's something that a lot of people don't know until, well, they'll find out then, okay? So what we're talking about here under compensation is the fact that if your employer can direct you when to work and how to work and, like they tell you, you've got to be in the office on this day from this time to that time, and they can control, the certain days that you work. And, like, in other words, it's an employee-employer relationship. Well, then you're not an independent contractor. If they're giving you vacation time, which, heck, who would say no to vacation time? But you don't give independent contractors vacation time. If they're giving you a 401k plan, well, you don't get that as an independent contractor. So they don't get to step in both ponds. It's like you're either one or the other. So there's like specific tests to be an independent contractor. So recordation of closing documents is a form of constructive notice. And there's a number of things we do in real estate that's called constructive notice. In other words, when we notarize documents in order to file them in the public record, we do that in order to have constructive notice. Like mortgages, deeds, that's got to be noted. Those items have to be notarized in order to put them into the public records for constructive notice. Otherwise, people could get 30 mortgages on a property. There's got to be some way so that the lenders could know what's going on so things don't get out of control. Now, when you hear flip taxes, you should automatically know, when I hear flip tax, I think of co-ops. And flip taxes were instituted many, many years ago. First of all, co-ops are predominantly found in New York City. And, okay, flip taxes, you think of co-ops. And they were put into place because a lot of these big old buildings, they appreciated significantly. The values, these properties appreciated significantly in value. And they didn't have enough money. They didn't put enough money into the main components of the buildings, like the lobbies and some of the main structural parts of the building. Because remember, with a co-op, the common areas, everyone owns a piece of. You own individual apartments through what we call a proprietary lease. And I don't want to get into the whole co-op part of the program because that's a separate night of the program. So, there was dilapidated parts of the buildings that the flip taxes were instituted to help pay for. So that's the purpose of a flip tax. But what you need to know for test purposes is that flip taxes go with co-ops. If you know that, that's the points that you're going to get on the state exam. Okay? As we continue here. Overpaid real property taxes appear on the closing statement as a seller's credit. Know that for test purposes. Then we talk about good faith estimates, GFE, good faith estimates. Please know that that should be provided by the mortgage representative to the buyer within 3 days. Okay? So when your buyer sits down with a mortgage person, they should receive that good faith estimate within 3 days from whoever's taking their application. We go down a little further. We talk about condo ownership. The air, the land, the below surface areas are all owned as tenants in common. So we've got tenants in common, joint tenants, and tenants by the, do you remember the other one? I'm going to let you see if you remember the other one. What are the 3 types of tenancies we've talked about in the program, especially for the people that have been in the course for a bit? Tenants by the entirety, exactly. Very good. Okay? So those are the 3 types of tenancies that we have. So to look at this condominium ownership here, what you should know for test purposes is that with condominium ownership, the air, land, and below surface areas are owned as tenants in common. All right, next. Typical prorations that we see in real estate closings. Unpaid taxes are a credit to the buyer and a debit to the seller. Insurance paid is a debit to the buyer and a credit to the seller. Rent paid is a credit to the buyer and a debit to the seller. Now, what I do for you is I summarize the most common ones that you see. In other states, you actually have to know how to do a complete closing statement. New York isn't like that. And worst case scenario, you're going to have one question that's going to be based on one of these topics. That's worst case scenario. You may not even have a question about this. Okay. Next, we talk about a reverse annuity mortgage. The moment you hear about a reverse annuity mortgage, you should think to yourself, a loan that's associated with a senior citizen, and it's a loan where the bank actually makes payments to the senior citizen. So instead of you making payments each month, first of all, you have to be a senior citizen for this. And then second of all, and you don't need to know all the minutiae of this, because there's a lot you could learn about it, but you're not tested on it. And you really don't actually even get involved with that, not in your work as a real estate agent. So what happens is the bank makes payments to you each month. but you had to meet certain criteria. So senior citizen is your trigger word for reverse annuity mortgage. So in the question, you'll see the word senior citizen, and in the multiple choice options, you'll see reverse annuity mortgage. And then you're good. Move on to the next question. Then we have shared appreciation mortgage next. So with a shared appreciation mortgage, we're talking about commercial property. This is not something you're going to see with residential mortgages, which means as a residential agent, you're really not going to see this too often. Shared appreciation mortgages allow lenders to benefit from the appreciation of a property. So what happens is the lender benefits from the appreciation of a property. And the appreciation of a property's value in exchange for a lower rate of interest charged to the mortgagor. So when we cover, we're going to loop around again, but we cover mortgagor is the borrower, mortgagee is the lender. So the lender gives a lower interest rate in consideration of the fact that as the property appreciates, they're going to get a little piece of that appreciation later on. And that little piece of the appreciation that they get later on is why we call it a shared appreciation mortgage. Then we look at a package mortgage. Now, the package mortgage shows up quite a bit on the state exam. It includes personal property. Another name for personal property is chattels. Chattels is like an old-fashioned term. You definitely want to know that for test purposes. Knowing what I just reviewed with you, if you know that, that's all you need to know about it. But let's review the entire term. A mortgage that includes personal property in addition to the real estate being pledged as security for the loan. Now, you typically see this with condominiums. Closest in our area would be like Ellicottville area, like where resort properties would typically be found. That's often where you'll see it. But it's found all over the country. You'll find properties that have this type of a mortgage setup, okay? But again, all the years that I sold real estate, I never ran across this once. And I did sell real estate in the Ellicottville area as well. We had a branch office down there. You want to look over convertible mortgage. Then we look at Ginnie Mae next. Ginnie Mae was established in 1968. You don't need to know the year. That's not important. It's an agency of the Department of Housing and Urban Development. That's HUD. Now, you should know HUD, Department of Housing and Urban Development. And that's where FHA comes out of. FHA, Federal Housing Administration. They make capital available to lending institutions by purchasing FHA and VA mortgages. That you should know. Then we look at feasibility study next. It's a detailed statistical analysis. That's your trigger word. Detailed statistical analysis. Those words are part of any question where the answer is going to be feasibility study. So please know that for test purposes. It's a detailed statistical analysis of all facets of a project in comparison with data from similar projects, which may include data about site development, cost of financing, demographic information, traffic patterns, and the like. Feasibility studies are a huge part of any commercial transaction. You know, like, for example, if you have Walmart or Target coming into the area, they've got people that do feasibility studies all the time to see if it's even worth. In other words, is it even feasible to have Walmart come into a particular area based on the traffic patterns, the demographics of the area, based on the, you know, do people even have money in that area that makes it worthwhile for them to support that kind of a superstore, for example. So just the bottom half of page 25, we look at broker fast facts. And what we're doing now is we're reviewing some legal terms. In the bottom half of page 25, broker fast facts. Defiance clause. We're going to look at defiance clause now. A clause which is found in mortgages and leases that cancels a specified right at the occurrence of certain conditions, like the cancellation of a mortgage. In other words, when you pay the mortgage, the defiance clause says that once you've paid the mortgage, it's considered defeated, so it's gone. In other words, you've made the payment, it's done. It seems odd that you have to say that, but you have to say that because it's a legal concept that you're satisfying. Then we have the term assemblage next. Assemblage is the combining of two or more adjoining lots into one larger tract to increase the total value. This one is very popular state exam question. And this is something that we do in real estate on a regular basis, especially once you're in a business for quite a long time. So please know assemblage. Then we see blue sky laws next. Blue sky laws refers to the common name for those state and federal laws that regulate the registration and sale of investment securities. Timeshares are regulated under the security statute, and it's administered by the Department of Law and the Department of State. That phrase, if you have a highlighter or you can underline that, please mark down Department of Law and Department of State, because they go together. And I've seen that when I take the state exam probably every 4 to 5 years, just to kind of stay fresh on what you're going to see. And that's I've seen that on the state exam only twice, but for as often as I take it, that's enough that makes me want to share that with you. I want to look at declaration next with you. A declaration for a condominium contains a complete description of the land, building, and individual units, the common elements, with a percentage of ownership of each unit stated, and the bylaws. So this is something that when you buy a condominium, this is something that you're going to get every single time you buy a condominium. Take a look at the next bullet point, the developer or sponsor, what they file. Take a look at the Interstate Land Sales Full Disclosure Act. Make sure you read through that. They don't seem to ask much about that, so just give it a cursory review. For years and years we've been covering this, and they really hardly ever ask that. Then at the bottom of the page, we've got the 7 legally acceptable reasons for divorce. That was updated. In the last, I'd say, 7 years. They only had 4 reasons, I believe, and they modified that. We're going to turn to the gap part of the course now. We're going to turn to, that's the green section of your book. There's a green binder, like a green tab, and you're going to go page 36 in the gap part of your course, okay? Page 36. So page 36, we talk about state regulations from 1984 to present. Talks about the basically, what caused rent controls and how did it all start, going back to the early 1970s, all the way to 1984, all the way to the current times. You can give it. They're not going to test you on it. You can kind of give it a cursory review. Again, we don't read to you in the classroom. It's just, we know you can read on your own. Just give it a background read. It gives you like the progression of the laws as they come even up to 1993. Bottom of page 36, rent stabilization. Rent stabilization is prevalent in New York City. It protects some tenants from sharp increases that might take place upon lease renewals and in rents in general. So rent stabilization is referred to as the Emergency Tenant Protection Act, ETPA, in areas outside New York City. So for those of you that are new, anything that's bold is a testable item. You should know that. That shows up often on state exams. Please know anything that's in bold. I would make a flashcard up for that last item you see at the bottom of page 36, okay? Page 37, we have a little picture of the state there, and we show you like 2 major factoids there. On the left side of the state picture you see, outside of New York City, it's ETPA. To the right of the map, inside New York City, we call it rent stabilization. So the Emergency Tenant Protection Act, that's what ETPA stands for, Emergency Tenant Protection Act. That's outside New York City, and inside we call it rent stabilization. That you should know for test purposes. And the reason why is because on the New York State exam, there's questions about things that happen in New York City, just like the New York City people see things that happen about septics and wells. And they hate it. They hate everything you could imagine that we hate about New York City. They hate about upstate New York stuff. Like, they hate it. They're like, I'll never see a well. Why do I have to get tested on it? It's just the way New York is. It's how it goes. Top of page 37 is next. In New York City, rent control operates under the MBR, the maximum base rent. MBR is maximum base rent. In general, a maximum base rent is established for each respective apartment. Owners and landlords may increase rents up to 7.5% annually until they reach the maximum base rent. City landlords may also pass along any increases in the cost of fuel or labor costs they may incur. Okay. The underlined item. Let's take a look at the underlined item. All rent-controlled apartments that are in buildings containing at least 6 units or more that are vacated become a rent-stabilized unit or become a decontrolled apartment. That is, one that has been removed from regulation. So 2 concepts that are covered there. A decontrolled apartment is another name. A decontrolled apartment is another name for an apartment that's been removed from regulation. It kind of makes sense when you think about it, okay? And also know that rent-controlled apartments that are in buildings that have 6 units or more, if they become vacated, becomes rent-stabilized units. So you should know that what we just covered there. Like, be familiar with that. Usually the most you're going to see as far as questions from this section, about 2 at the most. And again, we address that again in the middle of page 37. I want to share with you in the box, there's a remember box in the center of page 37. In New York City, a rent-controlled apartment that is vacated becomes decontrolled. So you're probably, now if you're newer in the program, something about something about real estate writing that we want to share with you is that we repeat and repeat and repeat. It's kind of like it's like a standard thing in real estate writing. It's not because like I have early Alzheimer's. It's because it's just a way that you write in real estate. You repeat and you repeat because it's a licensing program. It's a way that we want to make sure that you really know how important things are. So we say it over and over again, so it really soaks in. Okay. So that's why you see these things over and over and over again within short sections, okay? Next, we look at the New York Rent Regulation Reform Act of 1997. We look at luxury decontrol. The landlord petitions the New York State Division of Housing and Community Development to deregulate an occupied unit if the monthly rental is $2,000 or more and the household has earned income of $175,000 or more for 2 consecutive years or more. Method 2, the apartment is vacated and the landlord raises the legal rent to at least $2,000 or more. At this point, the unit is considered destabilized. And then we bring up a did you know. Throughout the book, you'll notice I have a lot of did you knows. So New York's warrant of habitability requires that apartments be safe, livable, and sanitary. Appropriate heating, clean water, available hot water, keeping the premises free from vermin, infestation, etc. The warrant applies to common and public areas of complexes of any size, as well as cooperatives and condos. The warrant of habitability is for any place where people live. The warrant of habitability can be one of the reasons why people don't pay their rent. And you've heard me say examples before. And for those of you that are new this evening, if you watch some of our previous uploaded videos under our real estate exam playlist, you'll see that I referenced some of these in previous examples. It's really important that if you're a landlord in New York, that you make sure that your properties are safe, that they're well lit. Otherwise, people can find creative ways to not have to pay their rent. And you should be a good landlord anyways. You want to make sure that you're taking care of your property. You want them to be safe. You want there to be hot water. You want there to be, clean water. Like that's the warrant of habitability. Okay, let's look at page 38. So understanding New York's multiple dwelling laws and residence laws, page 38. I just want to bring to your attention the top of page 38, the top of 38. There's a difference between MDL and MRL. The average person doesn't even think that there's a difference, but there really is. Multiple dwelling laws and multiple residence laws, and it's all based on the number of people in the population for the municipality that you're dealing with. Okay, so page 38, what you need to know. You need to know whether it's MDL or MRL. And here's how you know. One side of your flashcard, cities with a population of 325,000 or more, so I would put on there 325K plus is an MDL on the reverse side of your flashcard. So you have a flashcard, MDL on one side. On the reverse side, you put 325K plus. Then your other flashcard, MRL on one side of your flashcard, MRL, it stands for multiple residence law. I think you'll know that, though. I don't know if I'd write that out, but MRL is multiple residence law. And then I would put like the less than sign, that's the little pointing to the left, right? The little less than sign, 325K. So that's less than 325,000 residences, okay? So let's take a look at this a little bit deeper now. Multiple dwellings are typically considered buildings containing 3 units or more. Some towns and villages have expanded the definition of multiple dwellings to include 2-family homes that are rented out. This is common in municipalities where student housing is prevalent. I want to share something with you that has changed, and maybe you're not familiar with it, maybe you are. In villages and towns like Fredonia, for example, let me see, how do I put this? 2-family homes that could be student housing has special restrictions put on those properties that were never in place before. You have to be real careful, and if you're selling real estate in towns, villages, and cities, like Lockport has special restrictions, and there's not even a college in Lockport that I'm familiar with. But if you're selling in actually, here's the thing, what I would do. When you meet with your broker, the person that's going to sponsor you, here's a question I would write down. You need first of all, you should have a place where you should have a place in your notes where you have a list of questions you want to talk to your broker about. If you don't have a place where you've written questions you want to talk to your broker about, start one now. And because I know I've given you things already to talk about since we've been doing these live streams, okay? And the one question that I would encourage you to ask, on top of all the other ones that I've encouraged you to ask, is, are there any municipalities that I'm going to be selling real estate in that have special rules for 2, 3, or 4-family properties that I need to be aware of? Are there any special rules in any of the municipalities that I'm going to be selling real estate in that affect me, that are for any 2, 3, or 4-family properties that I'm going to be selling real estate in? And what do I mean by that? Well, will any of those properties require a certificate of occupancy? Because some towns will require them under certain circumstances, whereas years ago they never did. You need to know this because when you're listing properties, you need to know whether they need to get updated, whether they need to be applied for. Years ago, you only needed those for properties that were 5 units or more, or sometimes 4 units or more. So the person hiring you, the sponsor, you need to ask them this question. When you're being interviewed, you need to ask them, are there any towns that I need to be aware of that I'm going to be selling real estate in that have special rules that I need to be aware of that affect me if I'm representing buyers or sellers who are buying 2, 3, or 4 family properties, and in particular where they're going to require certificates of occupancy, C of O's, certificates of occupancy. Okay? And the reason why we're talking about this is because, in particular, in the town of Lockport, 2 family properties have to be registered. And why I'm sharing some of this extra information with you is because you may have to, they may look at you and say, well, no, why would you ask a question like that? So that means you have to give them a little bit more information, because maybe the way you're presenting it, they're not getting it. So you have to give them a little bit more. And say to them, well, sometimes student housing, sometimes there's particular rules that affects the, they might have a rule even about Airbnb. You might want to ask, like your client might want to be able to do Airbnbs. They may say that to you. And you want to say, okay, well, you don't know what the rule is for Airbnb. If there's a particular rule for that. That's something that I never had to deal with years ago. Now it's very popular. People want to be able to Airbnb their properties out. Well, now you have to know these things as a real estate agent. There's so much more you need to know that you never had to know years ago. And even if you're not involved with that, they still want to know what the potential for the property is. Things that, never affected. You're not even going to be involved with that. But that's something that they're going to want to know the potential for that property. Okay. All right, as we continue on page 38. Second paragraph. In most lease situations, assignment of a lease involves a transfer of the lease contract from the original tenant to the assignee. That is your traditional definition of assignment. You're taking part of your rights as the person who has the rights to do something at that property and giving that to another person. The assignee assumes responsibility for payment of rent. Then we look at the definition of subletting next. Subletting refers to a transfer of part of the leased area. When subletting occurs, the original tenant is still legally responsible to the landlord. That you should know. In this case, the sublessee will pay some amount of rent to the original tenant, the lessee, and then the original tenant will pay the landlord. Tenants must receive written permission from the landlord, and the lease must address whether assigning or subleasing is allowed. New York's landlord cannot unreasonably withhold consent for an assignment. Otherwise, a tenant is entitled to be released from the original lease after 30 days' notice. Now, keep in mind that anything that we see in this section coming up is superseded by the rules that we saw under hot off the press. Hot off the press is that section that follows chapter 1 of your book. Chapter 1 of your book are all the new laws that kicked in July of 2019. There were a bunch of new laws that came about as a result of Governor Cuomo signing into law all the Tenant Protection Act changes. So that supersedes anything that might be addressed in this section, which so far I haven't seen anything. But as we go through it, I'll bring that to your attention. So next we look at understanding leases in New York. Commercial lease preparation is generally considered a daunting task, which is often referred to the expertise of a qualified real estate attorney. In New York, the assignment of a commercial lease can be prohibited. So the rules for commercial and residential very different. Like residential, much more straightforward. When it comes to commercial, not as many protections. Definitely not as many protections when it comes to commercial. Okay, I want to make sure you're familiar with that. There are various factors applied to determine if a landlord is being reasonable with regard to subleasing or assignment of a lease. They include the type or nature of the business involved, the financial qualifications of the assignee, the impact of the change on the tenants in the building, the business experience of the assignee involved, and the potential need for the physical modifications to the subject unit or the floor plan. So it's very, that's why attorneys really get involved. Usually what you do if you're a commercial practitioner and you're finding someone to lease property out is you're doing a letter of intent. And then the attorneys do everything else. You know, you're doing what we call brokerage. You're bringing about, instead of a buyer and seller, a tenant and a landlord. And you do the negotiating as far as price, and then everything else is the legal stuff that the lawyers will do. Let's see here, next paragraph. In the next section, you find some of the most common commercial lease checklist items that might impact your commercial clients during their negotiations. And then that's exactly, we have 35 items that we go through, the bottom of 38 and most of page 39 actually. And you can just read through that. You're definitely not tested on these items. I kind of went above and beyond. I just wanted you to have a really good base to work with. So kind of give that a very casual read through. The bottom of 39 though, ground lease is next, ground lease. And this actually was on one of the exams I had taken before. A long-term lease of unimproved land. Long-term is your trigger word for ground lease. A long-term lease of unimproved land typically found in areas where commercial activity is or will take place, or where the owner anticipates long-term value in the holding of the land as compared to selling it to a developer or business owner to owner and subsequently develop later on. A tenant will usually own a building or is allowed to do so based on a provision or covenant within the lease. Ground leases are typically net leases. That's worth knowing for test purposes. What we mean by a net lease is where the tenant will have to share or pay various costs of the owners, such as property taxes. Think about triple net lease. When you hear the term triple net lease, that means part of the taxes, part of the insurance, and part of the maintenance of the property. That's what a triple net lease is. That you should know for test purposes. Now, that's not what we need to know in this part, but it's just something that comes to mind. A triple net lease, NNN, triple net lease, is where you pay part of the owner's taxes, part of the owner's taxes, part of the owner's insurance, and part of the owner's maintenance. Okay, so definitely want to know that. That's a common state exam question. Okay, so make sure to read through the rest of that and then take a look at graduated lease at the bottom of 39. A lease where the rent typically changes from time to time as specified within the terms. Your trigger word for a graduated lease is rent typically changes from time to time. Time to time. That's what you'll see, time to time. You don't see that on anything else. If you see time to time, graduated lease will be your answer in a multiple choice option. In the case for retail property, if the business is new, it would be reasonable that the rent would graduate or increase by some percentage each year for a certain number of years. Page 40, we talk about an index lease. A lease where the rent is paid and is tied to some type of index, again, for a long-term lease. In some cases, the rental figure is adjusted based on a timeline relative to a government's cost of living index. And then we talk about the consumer price index in the middle of the page. You can give that a read through. Just give that a cursory review. They're not going to test you on it. It's not like an economics test that the state's going to have for your real estate exam. You don't have to worry about like it being some terribly awful exam like that. But just give it like a cursory review. Page 41, we look at contract essentials. The statute of frauds. Now we see this a few different times, statute of frauds, as we go through the material. You don't need to know that section 5-703, New York doesn't test you on that. That it's part of the New York General Obligations Law. But the other time that you do see New York statute of frauds is when we talk about the fact that things have to be in writing. That's the other time that we talk about New York statute of frauds, is that things have to be in writing. That's worth knowing for test purposes. So in New York, the statute of frauds states that contracts involving the creation of subsequent conveyance of an interest in real property must be in writing in order to be enforceable. There's significant potential for misunderstandings of verbal agreements, and as a result, all states have adopted various statutes of frauds. So essentially what I just said is true. The statute of frauds essentially states that it has to be in writing, and the specifics are addressed in the statute of frauds under general obligations laws. Okay, so we're going to look at the second paragraph next. So the attempt by states and the federal government to make uniform all laws relating to commercial transactions, which include checks, promissory notes, drafts, certificates of deposit, are based on the UCC. UCC is Uniform Commercial Code. That's not exciting. That's just what it is. Third paragraph. In some cases, a contract has to be removed, annulled, or taken back. We refer to this as rescission. Well, that's pretty straightforward. This may also occur when a contract is not performed by either party or when a party breaches it. Okay. Similar to an annulment in a marriage, the court orders the parties to be placed back to their original position before the contract was ever initiated. We see the definition for injunction. We see the definition for liquidated damages a little further on. In the middle, we have a box with another did you know box addressed. Under the doctrine of reformation, please know that when you see reformation, you should think of the word rewrite. Okay, rewrite. Bottom half of 41, we talk about earnest money deposits. A lot of miscellaneous things. We're kind of like wrapping up loose ends as we wrap up the course. Just so you know, we'll be talking about property management issues tomorrow, okay? But as we talk about earnest money right now, earnest, when you hear earnest, you should think good faith. Most of the time, your trigger word, when you hear earnest, you think good faith. So one side of your flashcard, earnest money, the other side, good faith. If you've got that, then you've got another point on that exam. Earnest money deposits are not, however, legally required in order to have a valid agreement. It's a customary thing that's done throughout the state. So you can read through the balance of that on your own. And then sometimes people say, well, how much is a good amount to get? Over the years, ideally, a good amount of deposit to get, if you could wave your magic wand, ideally, it would be great to get enough to cover your commission. You know, if you could get enough of a deposit that would cover your commission, you'll shave a week to 2 weeks off getting paid. So if you could get 6%, 6 to 7% of a deposit so that it's sitting in the escrow account, then you're going to save time for money to clear for you to get your commission check. That's ideal, and that's like that makes brokers happy like all over the planet if you can do that. But technically, you don't need to do that. There's nothing illegal about doing that, but it's nice if you can do that. No one will be sad if you can do that. Sometimes a buyer doesn't have that money to do that, but if you can, that's terrific, Got some more terms at the bottom of 41. Make sure to read through that. Page 42 is next. So now we're just going to look at some terms. We're just going to kind of go through, look at some terms. Morgan has a question. Can you suggest they make a good faith deposit? It's actually, I have never not had an offer with a good faith deposit. I've never had someone tell me, you know what, Mike, I don't want to make a good faith deposit. It's so common to do it, to not do it would actually be odd. So I would actually say to you, when you sit down with your broker to get interviewed, add this to your list of questions and say, how often do you get a buyer? I think it's fantastic. When you sit down with a prospective sponsor, I think it's terrific for you to ask them questions. I hate for you to just sit down and they just ask you a bazillion questions and you're just like sheep being herded. I like it to be a give and take. I just think that's such a better situation. I think it's better. I just think it's better. And ask them, say, how often do people in your firm not get good faith deposits from their buyers? See what they say. I think it's rare. I think it's really rare. And if they tell you, oh, it happens, about a third of the time, find out. Can you tell a buyer that a large amount could get a better chance of the seller accepting it? Yeah, well, and Gino, you bring up a good point. So in a competitive situation, which we have been in for quite a long time, and again, it all depends on what's happening in the marketplace. Markets change. It's very cyclical. If you're in a competitive situation, supposedly it's always been well understood that a bigger deposit, all things held equal, shows a stronger buyer and shows a stronger offer if you have a bigger deposit. But if it's a lower price with a bigger deposit, you got to look at the whole picture. If someone's getting an FHA loan, well, then somebody with a smaller deposit with no, you got to look at everything. Somebody that's getting an offer that has, maybe they waived their home inspection. Well, now all of a sudden that one's more popular. But if they're going for a VA loan, which is more strict, well, then all of a sudden it's not as popular. So it's really going to be, there's quite a bit involved. You got to really pick and choose and say, okay, well, but it's not all about the money. And then if someone has a contingent offer, that's another thing to think about. So I just can't say yes, a big deposit is all that matters. It's not. But yes, singularly speaking, that is important, because it's nice to show that you have a well-qualified buyer, for sure. So in itself, it sounds good for sure. So page 42. Read through the top. That's good to know. Apportionment. We want to talk about that. So apportionment is the division of expenses between a buyer and a seller. And we do that when we're doing a closing statement. The attorneys do that. The buyer's attorney and the seller's attorney are involved in the apportionment. And usually what will happen is the seller's attorney will review what the buyer's attorney has prepared, make sure everything's proper. The binder, we've talked about the binder before. We know, of course, that's something that's done in downstate New York. We get into more detail here, though, so we'll take a little look at it now. A written document used for the purchase and sale of real estate, similar to a purchase offer, as it outlines a scope. It outlines the scope of a real estate transaction. Notice when we talked about this the other evening, that it's not the same as a purchase offer, but it does give you the highlights. And then what happens is the attorneys basically run with it and they do all the details. And we'll see that in downstate New York. That's the binder is what the downstate New York people use compared to us upstate. Yeah, all the rest of it's what we've talked about before. The last sentence, though, commercial sales sometimes employ binders due to the complexities involved in the transaction. So, yeah, so that makes sense. Okay. And then in the bottom half of the page, we identify the comparisons between binders and purchase offers on each side. Then we have the term, the Latin term caveat emptor, let the buyer beware. That's at the bottom of the page. Now, that used to be the way we did real estate. When I got into real estate, it was always caveat emptor, let the buyer beware. But now the way we do real estate and the way we've done it for a long, long time is disclose, disclose, disclose. It's not like, haha, buyer, you figure it out. It's we're going to tell you and tell you and tell you, disclose, disclose, disclose. That's why if you can make up a sheet where you just disclose all the laws and regulations that could affect you as a buyer of real estate in New York and all the laws that can affect you as a seller of real estate in New York, this way you've told them everything. They can't say you didn't advise them accordingly. And you might have noticed we have a really good video that's been uploaded for you that identifies all of that. I think I call it a great way to minimize your liability in New York. I think it'll make a difference for you. I hope you do that. And it's a great way to review. You got the time to do it now. Why not consider that? Page 43 is next. Page 43, agricultural district. There's a number of places in Western New York where we have agricultural districts. Eden, New York, parts of Hamburg have agricultural districts. You can Google and probably see a number of them. If you work anywhere south of Buffalo, there's a number of them. There's a number of them east of Buffalo as well as you head towards the county line, heading towards the Rochester area too. So agricultural districts are areas designated by municipalities to serve as an area where farming or related activities might occur. Okay. Forbearance at the bottom of page 43 is next. The act of refraining from taking legal action for payment of a mortgage, even though it is legally due, or the lender has the right to do so. Lenders typically offer forbearance when the original owner is a relatively good credit risk and or the interest rate on the loan still favors the lender. We talk about installment sales contract at the bottom of 43. Just give that a cursory review. Page 44. Talk about the advantages of installment sales contracts. Just give it a quick review. Integration, just a quick review. Actually, everything else on 44, just one quick review. Don't knock yourself out. Page 45, the New York Lawyers Fund for Client. Never, ever hear about that. I don't want to say don't read it, but just give it a quick review. We talk about contract and lease considerations at the bottom of 45. It's where we talk about the carbon monoxide detector, affidavits. You're not involved with that, but when you're walking around the house and you don't see a carbon monoxide detector and you don't see a smoke alarm or smoke, you have to have a carbon monoxide and a smoke detector at the house. And usually what will happen is when the home is when a home inspector comes out, that's usually when you find out if the home doesn't have what it's supposed to have. You don't really get involved with carbon monoxide and smoke detector things. But what happens is, as real estate agents, you don't, you're the master of ceremonies, like you got to know a little bit about everything and make sure everyone's doing what they're supposed to do. So people are going to ask you questions about everything and you don't want to be clueless. So that's kind of why you see us covering so many different things, They're going to find out if the home inspector said, well, they're missing a smoke detector. They might have a form from the lawyer and they're going to say to you, if you're around the day that they get the form from the lawyer, well, why do I have this form? You know what this is about? Well, you'll remember from the day that because we're talking about this now. Oh, well, yeah, you got an affidavit. It's typical. You have to sign the form that says that you have that. That's part of what you have to do to close on the property. That's what this is talking about here. Okay. Page 46. So you should know municipalities may require more detectors and may go so far as to state specifically where they need to be placed within each level of the home. You may not have done this or known this before, but if you Google and go to each municipality, like Cheektowaga, town of Amherst, all the different municipalities, they have sections of their website that show you, most of them do, at least the ones that I've investigated, and tell you that if you have a two-family home, this is the locations of where smoke detectors and carbon monoxide detectors have to go. If you have a single-family home that's one story, or a single-family home that's two-story, this is where smoke detectors and carbon monoxide detectors have to go. So it's like they get really specific, you know. So but a lot of people don't even know that that exists. So depending on, like, I know our home inspection students, we teach them that they go and they can look on the websites, and then they can advise their clients that this is where they go to find out where they can, you know, set up, you know, they can get the information. Because, you know, our home inspection students, we're not supposed to go and place carbon monoxide detectors or confirm that, you know, we just look to see that the minimum state guidelines are met. But when you own a home, you want to make sure that you're meeting the guidelines. Don't forget the warrants of habitability. You want to make sure that everything is the way it should be, because you don't want someone saying, well, I don't have enough smoke detectors in the home. You know, you want it to be safe. You know, it's big responsibility. Owning a home is a big responsibility. You want your people, when you're renting out your property, you want it to be safe. When you're, you know, you've got your family and your children in the home, you want them to be safe. You want to be safe when you're living somewhere as well, you know. Bottom of page 46, we talk about, we're kind of wrapping up some loose ends with things here. We talk about some finance and land use regulations too. Predatory lending is a topic we're going to talk about now. A significant number of mortgage brokers and well-known national lenders have been found guilty of predatory lending practices they've taken care of. So what's happened, predatory lending is when lenders take advantage of a certain part of the population. And that's what we're going to talk about right now. They take advantage of consumers seeking access to numerous financial products, including mortgages and home equity loans. Continues on page 47. Most predatory lending practices involve subprime borrowers. So subprime means that they either have credit scores that don't meet a certain criteria, or they don't meet financial qualifications. So maybe they're not on the job for 2 years or more, or in the same line of work for 2 years or more. So they don't meet prime lending standards. So they're what we consider higher risk. So they may have lower FICO scores or credit scores. That's all addressed at the top of page 47. Second paragraph talks about what a credit score is. Give that a cursory review. You don't need to memorize credit scores. A state exam won't talk about what credit score you need to have for this, that, or the other thing. They don't worry about that. Yeah, so just give this a cursory review. Nothing major here to worry about getting tested on. You don't need to know that the New York anti-predatory lending law was signed into effect April 1st of 2003. You will not be tested on that. Again, just give it a cursory review. Page 48 talks about what happens if a mortgager can prove that a lender or a mortgage broker violated the law. It talks about that at the top of page 48. Then in the middle of page 48, we talk about land use regulations. New York has the State Environmental Control Review Act. Now, this is something that could show up, usually one question at the most. So please know what SEQRA is. SEQRA. Please know this for test purposes. Again, SEQRA. That stands for the State Environmental Quality Review Act. It applies to environmental control over privately developed land. That's what you need to know. If you put that on one side of your card, privately developed land goes on one side, and then SEQRA, SEQRA on the other side, that's what you need to know. And then you're good. It's all you need to know for state exam purposes. It's not like this will make your life better as a real estate agent every day. I promise you. I wish it would make your life better. It won't make your life better as a real estate agent. But it will definitely get you another point on the exam if you happen to get it. Again, it doesn't show up a lot, but if it does, that's what you need to know about it. Because people don't always remember that it's the private developed land. They don't always remember that part. Nothing else exciting there to share with you, though. Yeah, that's all we've got there. I know that you see Article 9A at the bottom half of 48. I know the first thing you think of when you hear 9A is subdivision and development, right? Right? Yes. You're shaking your head, right? I know, right? Okay, good. Yeah, okay, so page 49 is next. So we talk about construction and environmental related issues now. So the New York State Department of Health provides guidelines for construction of on-site wells. Thanks, Gina. So during one of our earlier reviews, I shared with you the importance that one of the most common questions you get is, what agency regulates septics and wells in New York? New York State Department of Health. NYSDOH, Department of Health. NYSDOH. Please know that. Matter of fact, if you could make up a flashcard right now, it would warm my heart. Okay? NYSDOH, New York State Department of Health. One side of your flashcard, you do NYH, NYS, New York State Department of Health. And the other side regulates septics and wells in New York State. That's such a common state exam question. I would bet you $1 you'll see it on your state exam, but just $1. We're going to move on. So we're on page 49. Page 49, you want to know about the Department of Health. They regulate septics and wells. You don't need to know all, like, wells need to be a distance. Like, give it a cursory review. Just give it a cursory review, no big deal. Remember, like at the bottom half of the page where we talk about, remember, the New York State Department of Health, under 1,000 gallons and or 5 or more connections. I know it just doesn't show up much. I really, like, if your brain is filling up too much, don't knock yourself out. Don't knock yourself out about remembering that. I feel like there's too many other things that are going to show up. There's a much better chance it's going to show up. Don't knock yourself out about that item. I wouldn't knock yourself out over that. But it's there. At least it's there. If you happen to have a photographic memory, fantastic. Let's go to page 50 though next. Page 50. Okay. Well facts. Give it a quick review. You know, the state has not been asking a lot of questions about, you know, what are the components of a well. And most people are happy about it. I have not talked to a lot of students that are like, wow, I wish the state would ask more questions about what makes up a well. You know, it's great, you know. Or what makes up a septic system. You know, at one time, though, I can tell you about 12 years ago, 12 to 15 years ago, they were asking a lot of detailed questions about, you know, what are the different components of a septic system? Really, they were asking questions like that, but they're not anymore. That's at the bottom of 50, though. So, you know, distribution box they wanted to know. They want to know about the absorption field, but they don't care now. Top of page 51, though, percolation. You should know the term percolation. It's at the top of page 51. Percolation refers to the movement of water through the soil. The movement of water through the soil. So we do perk tests to make sure that a septic system is doing its job. That's how we determine that the septic system is doing its job properly. Okay. Energy code is at the bottom of page 51. So the state energy code applies to all new commercial and residential properties. Includes manufactured housing. The code regulates the building envelope. You've heard me reference building envelope when we talked about construction. That's the outside part that keeps the snow and the rain and all the elements out, the wind. Just give this a cursory review. You don't need to know the third paragraph. You don't need to know about the dates. We don't care about dates. Additional construction terms at the bottom of the page. Give everything a read through, but sill plate you should know. You should know sill plate at the bottom of 51. The bottom horizontal member of a wall building to which vertical members are attached. The sill is, this is what you need to know for test purposes. The sill plate is the lowest wood framing member of the house. The sill is the lowest wood framing member. So on one side of your flashcard, you put sill plate. On the other side of your flashcard, you put lowest wood framing member. And that's actually, the sill plate is actually what you screw the anchor bolts through the sill plate to attach the skeleton wood framing member. In other words, the skeleton of the house gets screwed into the foundation by screwing it through the sill plate. That's how we attach the superstructure to the substructure. Okay? So anchor bolts is how we attach the top to the bottom. The skeleton framing member gets attached to the substructure, the foundation, because holes are drilled through the sill plate. But you should know, sill plate's the lowest wood framing member. That shows up frequently on the state exam. Page 52. Pitch, top of the page, pitch. Pitch refers to the slope of the roof. Read through the rest. The definition of conduction you should look at. Top of page 53, conduction. Conduction occurs when heat is transferred within an object or from one object to another by actual physical contact. Okay? Conduction occurs when heat is transferred within an object or from one object to another or by physical contact. Then no convection. This is shown up on the state exam. Convection is the transfer of heat between objects that are not touching each other. That's the difference. Notice the difference between the two? Convection is when they're not touching each other. Radiation is the third way that heat's transferred. So all of this involves heat transfer. Radiation is the third way heat is transferred. The warmth radiates outward from one body to another. Oh, the bottom of 53, we talk about R value. The higher the R value, the better the insulation. In other words, the better the insulation. You should also know that R values are additive. So if I have an R value of 10 and an R value of 20, then I have a total R value of 30. Because 10 plus 20 is 30. That's all. It's not exciting, but that's what it is. So the higher the R value, the better. And we talk a little bit about R values at the bottom of 53. Page 54 talks more about R value. You're not tested on like the difference between fiberglass and loose fill and cellulose. You don't, like, that's when I talk about a quick read through, just give that a quick read through. Talk about heat pumps and air conditioning systems in the middle of page 57. Just give it a quick read through. One thing you just should know about air conditioning is that you don't want to have air conditioning run unless it's at least 65 degrees or warmer. You can really mess up the compressor on an air conditioner if it's not at least 65 degrees or warmer. And you want it to at least been turned on for at least 24 to 48 hours. If it hasn't been turned on for at least a minimum of 24 to 48 hours, you can also mess it up that way too. So, but most home inspectors will know that. Okay. Page 58. A heat pump provides heating and cooling. The problem with heat pumps in our area is that once it gets below the 30-degree range, like 35, 32 degrees, heat pumps are less effective in providing heat. So that's why a lot of times you need to have a furnace as well as a heat pump. And because heat pumps are expensive, the problem is that who wants to pay to have a furnace and a heat pump when you can just have a furnace and an air conditioning system, or no air conditioner. I mean, you can just have depending on the size of the home, you can just have either a central air unit or a a window air conditioner, depending on the size of the home. So, but a heat pump is nice because it does give you both cooling and heating. And you'll find as you go further south, they're much more common. Even though the New York State Association of Heat Pump Distributors is in Rochester, and Rochester's weather sure doesn't seem to change that much from Buffalo's weather. Call me crazy, but yeah, but that's, so you'll find a lot of heat pumps as you head more east from the Buffalo area. Don't know what that's all about, but they've been around a long time. Well, long story short, yeah, heat pumps provide heating and cooling. And the way to know if you have a heat pump is to look at the data plate on a unit, and it'll let you know if it's a heat pump as compared to a central air unit or not. Okay. Page 59, we talk about plumbing terms that you should know. We talk about different types of pipe. Give that a cursory review. Talk about copper, galvanized, lead, PVC, different types of plastic pipe that you'll find. Again, give it a cursory review. One thing I want to let you know towards the top of the page, we talk about galvanic action. Galvanic action is something you see on copper pipe, and it's kind of like that green, goopy, like it's green, and it's eventually going to leak, and many times a home inspector will bring to the attention of your client to recommend monitoring if it's observed. But if it's too significant, a home inspector will often recommend further review by a qualified plumber. It all depends how significant the galvanic action is, because eventually it's going to leak, and you just don't want it to leak. You know, you never get a leak at an opportune time. It's always at a least opportune time. So you always want to watch for galvanic action, okay? Sounds delicious. That's funny. Okay. Page 60. So cast iron. Cast iron, you probably, if you've lived in an older home, like I'm talking about a home that's over 50 to 60 years of age or older, it's a real big, thick, clunky kind of piping that you'll see in the basement. Usually when you walk down the basement stairs, you'll see it. It's big and black, and it's just like you could, like if it fell on you, it would probably kill you. You know, it's like real, it's really thick, and it's your main waste pipes for the house most of the time. That's what we have described on page 60. The copper pipes, that's all nice there. You see that described. You got some brass. Polybutylene is described at the bottom half of 60. Give that a cursory review. You're not really tested on it too much. There's actually a website called polybutylene.com, which is full of, if you're ever really depressed and you just want something to push you over the top to be more depressed, go to polybutylene.com. That will definitely throw you over the top, because you know what? You just do that. I don't want to ruin the surprise for you. Just do that someday, and then you just do that. Yeah, I won't say anything more. Top of page 61, that is a pressure reducing valve, and it looks like a bell. And you often see that near your main water intake of your home. Sometimes you'll see that near your washing machine. That's a pressure reducer valve. It looks like a bell-shaped thing, and it helps to reduce the water pressure coming into your home. And it's an important thing. You want to have that. You should check and see if you have one in your home at some point. And if you do, let us know. Let me know tomorrow when we see each other again. It should look like that. And you don't want the water pressure above 80. 80 is kind of high. It's ideal to have your water pressure under 80, above 50, you know, not below 40. 40 is a little bit on the low side, because it puts a lot of pressure on your, it ruins your valves and things if your water pressure is too high. And you don't want a thing called water hammer either. You know, that's a less than optimal situation in the home. So bottom of 61, we talk about electrical systems in the home. Okay. So electrical fires are not a good thing. 485 people a year die from electrical fires. You're not tested on that. I'm happy to tell you you're not tested on any of these numbers you see here. You're not tested on. But the one thing that you are tested on, which I don't see it here, but it is in the other part of the book where we talk about construction and electrical topics, is the wire gauge, okay? Please don't forget with wire gauge, okay? Gauge, G-A-U-G-E, wire gauge. The higher the number, the smaller the number is in terms of wire gauge. So the higher the number, the smaller the wire in terms of wire gauge. So the smaller the number in terms of wire gauge, the thicker the wire. So that means that the thicker the wire is, the more amps, A-M-P-S, or amperes, the more amperes the wire can carry safely. Because what happens is amperes is what heats up the wire. As amps goes through the wire, think of the wire as a highway, and amps are cars. So the more cars on a highway, they're racing down the highway, okay? It's heating it up, heating it up. And if you're making the highway narrower, 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 but you got the same number of cars going, well, that's what causes it to overheat. So that's why we want a wider highway. And the way we get a wider highway is to have a lower number gauge. Because remember, for test purposes, the lower the gauge, the thicker the wire. That you should know for test purposes. The lower the gauge, the thicker the wire. The higher the number, the smaller the wire, the less it can carry in terms of amperes, okay? Stephanie says that's on page 150 of your book. The other item on page 61 I want to bring to your attention is the term service lateral. Service lateral is the last paragraph of page 61. Service lateral, when you hear that phrase, that means underground service to the house. And you usually see service lateral in new subdivisions. In new subdivisions, service lateral means that when you look out, you don't see the utility pole with the wires, because it's underground. Everything's underground. In older subdivisions, you see this, you see the overhead wires that bring the power to the house. Okay? We call that the service entrance. But when it's underground, we call it a service lateral. Okay? Can't tell you that you see that on the state exam much. Home inspectors see it a lot, but I can't tell you that you're going to see that too often. Page 62. So lots of pictures on page 62 and 63. This is where we end for the evening. The ridge pole on the top of page 62, the ridge pole. So the lowest wood framing member is the sill. Remember the sill, S-I-L-L. The highest wood framing member is the ridge beam or the ridge pole or the ridge board. The ridge, anything is the top. R-I-D-G-E, ridge board, highest wood framing member. Okay? The rafter is the other one I would know on this picture. The rafter are those angled pieces that you see. You should know that. In the bottom corner, I would know cripple stud, C-R-I-P-P-L-E, the cripple stud. That's right near the page number, 62, cripple stud. And just in your notes, put the word jack, J-A-C-K. Another name for a cripple stud is a jack stud, J-A-C-K. A jack stud and cripple stud, they're the same thing. Just in case the state exam calls it a different thing, and if you happen to see it. You may not see either one, but just in case. A cripple stud and a jack stud are the same thing. So page 63, just look at the middle picture where it says anatomy of an interior wall. Look at the header. Look at the header. Know a header. Header's good. I would know a header. Yeah, header. That's all. Header. Just look over the pictures otherwise. Nothing else that's really I would knock myself out over.